Hello, everybody. Well, firstly, thank you, Rosie. Thank you for the handover. We're going to do this as a sort of dual presentation. I'm Craig Ralph. I'm cost counsel at King's Chambers. The other person on the screen that's come in is Paul Hughes. He's also a member of the costs team. Just a sort of brief intro as to who we are and how we got into costs. And then we'll explain what cost and litigation funding is. I came to the bar late in life, despite the almost blemish and line-free visage that you can see down the lens of your camera. In fact, I came to the bar when I was 40. I've been here now quite some time, pushing on towards 19 years. So, but I had an alternate job. I was a theatrical agent, so this is very much a different career. The reason I raise that at the outset is because this is a Zoom forum, and therefore I can't see you all as participants. I can just see the list. I think there's about 96 of you. I don't know if any of you are coming to the bar or intending to come to the bar as a second career, and whether or not some of you have, shall we say, a little bit of mileage on the clock. All I can say is that if you do it, it's rewarding. It's something you should take a leap of faith into if you're at all in doubt, because it will welcome you. There is, I think, no bar to anybody coming to the bar, if you'll excuse that pun. And so I hope that helps any of you, as I say, that have got a few miles on the clock. I got into costs, as one often gets into any area of practice at the bar, purely by the happenstance of who my pupil supervisor was. I initially did some PI work and some housing work, and then I started to do costs work alongside that. And that practice built and built and built during a time which was known in certainly to civil practitioners as the period of the costs war. It was a time when there were significant challenges being brought right the way up the hierarchy of the court chain in relation to the principles of recovering costs. There were very technical arguments raised as to the enforceability of a client's retainer, the aim of that being to avoid the obligation to pay costs when somebody who had lost in litigation was ordered to do so. And there was a lot of work about, and I found myself doing nothing but costs. And eventually, after quite some period of time, I realized that I hadn't done personal injury work for so long, I hadn't done housing work for so long, that in fact, if I actually accepted instructions, I might be letting somebody down. So I simply then transitioned into becoming a full-time cost practitioner. So that's who I am and how I got into costs. And I'll hand over to Paul and he'll explain his position.
Thanks, Craig. And again, I echo Craig's thanks to Rosie. That was an excellent talk. We better stop in about 2 minutes if there's as many questions for us, although I suspect there it isn't. I came to costs in a slightly different fashion to Craig. I went to school, university, bar school, and then straight into tenancy and straight into pupillage and then straight into tenancy at King's. So I followed a very linear path. None the worse for it, I hope. Probably just as many miles on the clock, certainly legal miles on the clock as Craig. And we've practiced costs together now in Chambers for a lot of years, as to which you'll hear a bit more later. I got into costs through Mark Friston, who was effectively my costs pupil master. He is now, I think it's fair to say, one of the preeminent authorities on costs. He certainly writes the book that is used on costs and in cost disputes, and his reference is made to it in, I think it's been in the Court of Appeal, but certainly in the High Court. Costs is, again, was a secondary start to me. I started with PI and ClinNag, and you'll have heard those talks. I'm sure have been very interesting for other members of Chambers. I started to do costs, and like Craig, it sort of morphed into its own practice because there were lots of cases about in the early 2000s and up to 2010, 11-ish, that were highly contentious because they facilitated defendants, insurance companies, if they raised the right argument and ran it well, to avoid any liability at all because of what's called the operation of the indemnity principle, which we'll explain in a minute, because it's really the bedrock of cost litigation. And so I moved on from there and took on the costs mantle. So it is an excellent, it's an interesting area of work. It's well regarded, if regarded slightly as slightly dull, and I think wrongly so, because it's not. And certainly each area of law, of course, has its own sort of lines of boredom, but costs is certainly varied, and it's a national practice that we have at King's. So a little bit, that's enough about me. Craig will just talk a little bit now about what costs is, and I'll add on after a few minutes just to sort of give my view on what it is, because the question as to what costs is probably the first question on your lips, because everybody knows what commercial litigation involves. It involves companies arguing about lots of money. It involves chancery, involves property and leases. Personal injury involves injury and death, as does political negligence. But what does costs involve? Well, Craig probably highlight that for you now.
Thank you, Paul. The title of this particular segment of today's presentation was Cost of Litigation and Funding. It's probably easier to start with litigation and funding because it's a fairly self-contained concept. Litigation funding is a fairly modern investment vehicle, really, whereby the money can be put into the pursuance of litigation. It's almost as an investment, and by dint of that support and that money being placed on the table, then the case can be run, the case can bring resources to bear through solicitors and barristers and experts. And so it allows those that perhaps have short pockets or not deep pockets to maintain themselves within litigation that otherwise they could be effectively priced out of. It's a very specialist area, it's a growing area, and it's an area which has only been legitimised in the last few years. For many years in this country, it was referred to as champetty of maintenance and was seen as being unlawful because, in effect, you were involving yourselves in somebody else's fight, and that was always for public policy reasons seen as being something that shouldn't be countenanced. So that's a fairly modern device. It's self-contained, and it's simply a commercial funding vehicle. That's the element of what litigation funding is on a broad scale. Cost. Well, what is cost? Well, I suppose it breaks down into two elements. But it's all predicated on the fact that in this jurisdiction, we have what is known as cost shifting, the concept of loser pays. The notion predicates on the idea that if you come, you fight, you lose, then you pay the price of the fight. That applies to both work that is in the civil jurisdictions and the criminal jurisdiction. There are certain nuances and differences, but effectively it's predicated on a cost shifting basis. There are some areas of law where the process doesn't apply or doesn't apply to the same degree because the sum of costs is controlled, and there are significant movements now within mainstream civil law to bring in a series of fixed cost regimes to again control the amount of costs that can be expended, and that extends through into the notion of cost budgeting for multi-track cases as well. But in essence, it's simply determining the principle of who pays whom, and then the quantification of the costs. Why does it become a specialism? It becomes a specialism, I think, for two broad reasons. Firstly, it's of significant importance to the parties in the action. Cynically, when you look at some of these actions, you could conclude that it sometimes takes on more importance to them than the actual argument that underlines the substantive proceedings, and that's often because the costs outstrip the value of the damages, and because other stakeholders have have a hand in that, whether they be defendant insurers who are backing parties in road traffic accidents, or backing commercial entities through public liability or employers' liability insurance, or whether it's claimants who have entered into a conditional fee agreement with their solicitors on a no-win, no-fee basis, and therefore there's the added dimension of solicitors who want to ensure that the amount that they get paid is maximised. We'll come on to it later, or perhaps Paul will, when we talk about what sort of work do we get in the costs team. But as an adjunct to what I've just said, it's worth noting that because it is a specialism, because it is so important to so many significant stakeholders, it's actually very lucrative, in the sense that it remunerates those of us at the bar to the same sort of extent that you would expect from reasonably heavyweight commercial work. So for those of you who are slightly more mercurial and perhaps avaristic, then this is an area of law that is that perhaps has its own individual attractions, for not least of which your bank manager's own peace of mind. I'll hand over to Paul now. He's going to quickly camp through what sort of work we do in the cost team. We'll then talk about the difficulties that COVID's thrown up, and then I think we'll try and leave at least 10 minutes to deal with questions. So we'll camp through the next segment fairly quickly, hopefully. Thanks, Paul.
No problems. Well, thanks, Craig. That probably unintentionally nicely segues into what I was going to say as a sort of addition to what Craig said about the information that Craig gave you about what costs was and why it was a specialism. One of the points that underlines costs law is that you are not entitled to recover from the other side. So the paying party, the loser that Craig referred to, more than you are entitled to recover from your clients, or rather, strictly speaking, the client, because costs are always the client's costs, not entitled to recover from the other side any more than they have to pay their solicitors. And that is fundamental to costs. It's called the indemnity principle, because the payment is an indemnity in respect of the liability to the solicitor. One of the key points in costs, and this is where a lot of arguments arise, is because costs is not, it is a creature of contract. It's a creature of the common law and statute, but it's also a creature of contract. And your retainer with your solicitor is a contractual one, but it's not absolute, because costs are subject to extremely narrow exceptions, always subject of assessment. A solicitor cannot simply agree to charge their client £5 million for a piece of work without any qualification at all. And then when they seek to recover that £5 million from the other side have to pay it, because that's what's been agreed with the client. Between the parties, there's a process of assessment, and there's a process of assessment between solicitor and client as well. And those are two aspects of costs which are far too intricate to get into detail in respect of now, but they are two sort of sides of the kind of work that we do. So we do between the parties costs, the loser pays the winner, and we also do solicitor and own client costs. So solicitor has a challenge from the client as to the level of fees that the solicitor has charged. So there's a consumer protection element to it. Those are two large genres of costs that we deal with. The specific types of hearings that we deal with vary in huge to a huge degree. Case management conferences, cost for case management conferences, big emphasis on budgeting. I haven't attended all of these talks, but I suspect that you've heard the word budgeting more than you need to. But it's an important part of current costs management, and a lot of focus in the last few years, that's 5 years really, has shifted to budgeting and being able to keep a cap on costs so that they don't run away. Things we do, detailed assessments, which are peculiarly costs related. They are hearings which assess, either between a solicitor and the client or between the parties to a win and a loss litigation, assess the level of those costs and whether they are reasonable. And there's a lot of arguments that are involved, hourly things like proportionality, hourly rates, whether the indemnity principle has been breached, individual elements of time. So whilst you do, of course, get a grand view of the entirety of the case, and you can argue general points, you have to argue particular points as well. And those particular points can descend to the minutiae, and they can be, is this worth 6 or 12 minutes? So the good thing about cost law is that you get the easy, but you also get the very hard and the difficult legal questions. Dealing with those, we move on to appeals. Both Craig and I have appeared in all levels of the court, including the Court of Appeal. Those are interesting hearings which deal with more, obviously with legal points, but either a first or a second appeal that's of sufficient importance to merit it. Those hearings run far and wide, but generally hearings are county court and high court. Probably more county court than high court in this area, but certainly we do get a fair share of good, interesting, juicy cases. That's really sort of the breadth of work that we do. Craig and I recently, and Craig, I was going to speak about this, Craig and I have recently managed to get instruction on a large case in the British Virgin Islands, and so we both called to the bar this week, which was a particularly interesting, well, frankly, a privileged moment. And we never would have thought when we joined Chambers and really moved on with the cost team that we'd be able to involve in something as huge and as significant as that. But it just shows that King's really doesn't know its own limits. We are an ambitious team, and costs is an area in which this sort of cross-jurisdictional practice is possible. So I'll just hand over now to Craig to deal with a bit of the that, and also the impact of COVID and electronic bundling that we now deal with, before we get on for some questions in a few minutes.
Thanks again, Paul. Okay, so what Paul was, I think, summing up there just towards the end is the breadth of work that you'll be receiving within the cost team at King's. I ought to make the point that outside of London, probably the King's cost team is certainly the biggest and we would say the most successful. And as Paul has said, the opportunity to work and do work in the British Virgin Islands is a huge honour. I ought to make the clarification that when Paul referred to getting called, he didn't mean called to the bar. He's clearly called to the bar in England and Wales. It was simply the addition of being called to the bar of the Eastern Caribbean Supreme Court, which occurred this week for both of us. Of course, these are challenging times, and we were called to the British Virgin Islands bar over Zoom, and that's as a result of the world in which we now live in. And certainly when the pandemic struck, there was some concern as to whether or not cases that were document heavy, and costs cases are very often, certainly in the advocacy and the detailed assessment type arena, very document heavy, and it's whether or not that could be managed within a virtual environment. And that, of course, has led to all practitioners in the cost team, but also in the wider cohort of legal practitioners, in having to embrace e-bundling and all that brings. My experience to date is, having got over the initial sort of teething problems of people coming to terms with the technology and ensuring that the platforms by which we communicated was stable. It's actually worked, very well. The only thing I would say is I can imagine that if you're starting out at the bar, it can be quite a sort of lonely existence anyway, because you're effectively a hired gunslinger that goes up and down the land presenting your client's case, and there is precious little time very often for the coming together of members of the bar for that sort of collegiate support that is so necessary, I think, to you growing your practice and you growing as a practitioner at the bar. So I do worry about that, but hopefully we'll all develop better mechanisms to support people who are coming in, and certainly I know King's is very active in that regard of supporting people as they come through. So if you do have any concerns that working remotely and developing a practice and developing your knowledge base might be difficult in these COVID times, then I can assure you that here at King's we are very much aware of that. It's at the front of our minds, and we're putting in place systems so that we can ensure that you get a proper and balanced pupillage and support in your practice. So that brings me really down to really the sort of questions. Now I'm going to let Paul deal with this because I'm sat here looking at it coming up, and I'm not quite certain how I open the questions up. So there we are. We've now finally exposed my Luddite capabilities. So, Paul, do you want to open up with some of the questions, or with the technology?
Well, Craig, I can assure you that it's like the two Ronnies. This I can assure you that certainly at least two of the people who are participants, Andrea and Kelly, have taken on board the fact that you didn't join the bar straight from school, and thank you for that. So you won't have seen that, but that's obviously they may not be the only ones, but they're not questions, but they're just comments that I thought I should pass on. And it really is right that there is no limit to joining the bar a little later on in life. I just didn't. Lots of members of Chambers did. A lot of people came in from teaching. Some were professor. I know that we've had professors from universities and people who've done all sorts of different careers. A few medics, so I really shouldn't let that put you off at all. It's what you make it, and particularly in these times, well, frankly, given that we're probably all going to have to sit in our homes rather soon, you might as well start studying and applying and make hay while the sun shines, rather than try and think of a travel corridor to explore, as I think we're all trying to at the moment. But I don't think there are any questions left, Craig, in relation to cost. Presumably that's because that every.
Well, terribly bored, which it is, or people having spent most of the day listening into this, their patience has finally thinned out, and I can understand on both. I perhaps say this then before we finish, because we're getting up towards that witching hour. I'm sure that Matthew, who's been the controller of this presentation and interaction today, will come on and thank those of you who have been participants to it. But personally, I'm quite flattered by it. I'm flattered to be able to speak to you all, albeit by this remote mechanism. So thank you from my behalf and on behalf of King's. If you do have any burning questions, however odd they may seem to you when you're mulling them over inside your head, please do type them up. I won't necessarily repeat your name if you don't want me to, but it's well worth asking those questions rather than simply sitting there and ruminating on them. So please do ask away. Now then, what have we got in there? So I'm working it out now. Look at me. I'm learning on the hoof. Here we are.
So one question I've got here is, I've always found that I've struggled to understand all the different types of costs that are involved in civil proceedings. What advice can you provide the most efficient way of remembering this information when doing the civil lit exams? My civil lit exams were quite a while ago, but if they're the same as that they were, and I suppose when I was taking them, it was, God, I think it was just about post CPR, so it was the beginning of the new cost regime. I'd be surprised if you were expected to remember all of the types of costs in all of the tables, because now there are a plethora of tables for different stages of settlement and different stages, certainly in civil litigation, and road traffic accidents and ELPL claims, different stages of litigation and different settlement points. I'd hope that they weren't quite so mean as to expect you to somehow remember all of those tables. The best way to remember, well, I think that as far as I would guess, the best thing to do is to remember broad principles, certainly as far as civil lit is concerned. the concepts of proportionality and the 8 pillars of wisdom that are in CPR 44, 3 and 4. You ought to remember those. You ought to remember probably the essentials about fixed costs for portal cases and fixed costs for cases which fall out of the portal. But I can't see that you'll need to remember everything. And if you are expected to remember everything, then you won't be able to, and nor will anybody else on your course. So it used to be far simpler, but it's one of those sorts of areas of law where you cut one head off and another 6 spring up in its place like a hydra. So I'm hoping that it doesn't cause you a problem.
I'm not sure actually. I'm just looking at the question again, whether it's that broad question or whether it's such a narrow question. If it's a broad question, then go and read parts 44 through to 47 really of the civil procedure rules, and hone in, I would expect, on part 45, as Paul said, all the different fixed cost regimes therein, and have a look at the different definitions of such things as trials and where the stages are, because I suspect on the multiple choice questions, if the civil exam is anything like it was when I did it, it can be a series of multiple choice questions and the answers are quite similar. So I simply read those, and so you have that process where you'll spot the obvious interloper when you do the multiple choice question. Somebody very kindly said, didn't have much of an interest in cost as an area of law before today, so thank you for bringing it to my attention, and thank you for the presentation. That's very kind of you. I ought to give you a word of warning. Obviously, anybody who does cost law is obviously and clearly terminally dim and boring. We are the type of people who, if you come across us at a dinner party and you ask the immortal question of how do you represent somebody if you know they're guilty, we will gleefully tell you that no, we work in civil litigation and costs. We'll then tell you about it, and you will quietly try to take your own life with a dessert spoon. That is the nature of cost law. But thank you for at least kindly saying that it was quite, we gave you some insight and interest into it.
No one's ever said that to you before, have they?
No, nobody's ever told me it was interesting.
Thank you, Abina. You really made their day. I'm going to send that round chambers. It's normally with well, we all joke with one another, don't we? I mean, people say to me that my stuff's really boring, and then I say to the planners that their stuff's really boring. But no, thanks guys. I think Ruth was saying as well that she'd never even knew, Ruth Stockley, when she was doing the planning talk, that she never even knew that planning law existed, before she came here. So hopefully, if today's event has served any purpose, it's just shown that there are some little corners of practice which, you might set your sight on. We struggle to find people who, when we interview, don't we, Paul? You're on the pupillage committee, or have been. Yeah. Say that they're interested in doing planning. Well, it's about a third of the work that we do in our chambers is planning. The cost team is a real growing area as far as from what I understand. So, if you want to develop an area in something like that, then it's a good way of standing out, I think.
And it's relatively easy to source on the internet. If you want to know about costs law, you just type it up on the internet, look at a few important cases, and you'll learn a lot about it. It's not a difficult or particularly obtuse area to search through. So yeah, have a look. But
also, I mean, apart from the sort of the underlying case, it can be one of the most important things actually that arises out of the litigation.
Yes, I think one of the points to bear in mind with cost law is it doesn't suffer the dabbler. And the reason for that is, of course, if you're not on top of it and you don't understand it and you go along and you make a terrible hash of it, the reality is that you're going to upset somebody quite significantly because they're not going to get paid. And not getting paid tends to bring out the very worst in people. So one needs to be aware that you need to be a specialist, not a dabbler. Now, the converse of that, or the mirror of that, is that cost is a speciality where if you are committed to becoming a specialist, you can fast track your career and your status very quickly. And there's a primary reason for that. And it's that costs isn't taught as a speciality to bar students. And costs for solicitors is only a series really of educating us to the accountancy rules and how you bill. And so it is a quite narrow and although connected speciality, it's quite esoteric in its own little dark art ways. And so if you commit to it, you can find that you can become quite a sought after practitioner in a relatively short space of time. It was certainly something that attracted me to it, coming to the bar as I did later in life.
Good. Well, I don't know if there are any more things on that. But yeah, as I say, I hope we've just given an impression today just of the various things that we do. It doesn't mean you have to come here if you come in thinking of applying with any specific idea about exactly what you want to do. I didn't. And people change their minds as well. You know, again, you don't have a boss. There's nobody telling you, well, you're in that department, that's your role. You know, people develop all sorts of different interests as they go along at the bar. I fell into doing what I do. I mean, never really took a conscious choice to do it. I think it's just because nobody else wanted to, probably. But I don't mean that in a bad way. It's a good anyway. Have you got anything else, any sort of final points to add? More generally, perhaps, about being a barrister here at King's, Paul, Craig?
Well, Matt, you will know that the chambers must be good enough because I was in the position 20 years ago of the people who are on this mini pupillage fair.
I remember.
It was I
remember your first appearance in chambers at the mini pupillage fair and going out late at night. Indeed,
it was all well. Yeah, unfortunately, we can't do that now. But I think it was this Thursday night that we would traditionally take people to All Bar One or some other. You know, I think we might have upgraded to Alchemist now, but it's probably too many. But it's a shame that we can't do that this year with the participants because that's always a good way to meet them. But rest assured, hopefully, you know, if you see our faces, mention that around about when we're all allowed to be places and all the caveats that follow. Feel free to come up and say hello. I was on the mini pupillage fair. I listened to your speech or your talk or somebody else's because I was definitely where you are 20 years ago. It just shows you that 20 years later you could be talking hopefully in non-COVID time to people in your position. So you know, if that's and I'm you know somebody who didn't expect to go to the bar, I don't come from family of barristers or anything like that, but I'm very pleased to have been at King's for the past 2 decades. So yeah, go for it is my encouragement.
Yeah, I'd echo what Paul said and simply pick up on my earlier point. Very often when you research through the sort of standard internet media and you go through the trade directories, you glean a certain view of certain sets as being accessible or otherwise. I don't know what your perception is of King's, but I can tell you what it's actually like. It's very open, it's very friendly, and what I would hope you see today, having listened to those of us at King's who are members who've spoken today, is the different personalities that are in King's, and I hope that that's shown you that we are a collective group of individuals, and that picks up really. And I'm just finish on the final point. I know earlier on there was a sort of sense in some of the questions that I've managed to decipher on the screen of how you stand out, and I'm very much a believer in be the best you can be. By all means, when you start going to court, you're learning your advocacy craft. Listen to the way other advocates do something, and if you think that that was a particularly good way of putting it, grab it for yourself and turn it into your own, and weave it into your own style. But don't ever become a parody or a mirror of somebody else. Be you. ultimately you'll thrive and strive and succeed at the bar because you're the best you can be. And we all come from different walks of life. We all come from different backgrounds. We're all different ages, shapes, creeds, colours, and ethnicity. But our commonality is a love for the law and a collegiate support for each other. And I can tell you unashamedly that that King's is very collegiate and very supportive. So if you are considering applying, I commend it to you. Those are my thoughts.
Great, good. Well, I hope it's been relatively enjoyable. And if anyone's got any other burning questions, then, I mean, feel free to email them into Chambers. If there's anything that occurs to you in the shower later on, or as you know, in the next few days that you think, well, I wish I'd asked that, that's absolutely fine. And yeah, the idea is each year just to sort of give a bit of a showcase of what we do. And I think it's, in a funny sort of way, the current situation has allowed us to do that perhaps more effectively. Subject, of course, to what Paul said about it being a real shame that we can't meet up personally. Okay, right, I'm going to sign off now. Thanks, Paul. And
thanks very much.
Thank you.
Okay.
Goodbye.
Bye-bye.
Bye, everyone. Thanks for joining us.